Now, in his 2015 book, The Paradox of Liberation, Michael Walzer deals with the question, how is it that countries that 2 or 3 generations ago went through secular revolutions face, at the beginning of the 21st century, a mounting wave of religious sentiment in their civil societies and widespread religious action in their political systems. Walzer discusses 3 countries, India, Algiers, and Israel. The roots of the current intense struggle between religion and secularism in Israel lie in Germany of the last 2 decades of the 18th century. In the course of these 2 decades, a Jewish Enlightenment movement developed in Berlin. Jewish Enlightenment challenged the confinement of Jewish life to the imperatives of Jewish religious law, the halakha, and the exclusivity of the leadership of the rabbis. Rather, it strove to create a fusion between Judaism's religious legacy, on the one hand, and the philosophy, the sciences, and the secular culture of European Enlightenment on the other. And I'll get back to German influences over Israeli culture for several times in the next few minutes. The rabbinic establishment understood the heresy embodied by the Enlightenment challenge to the exclusive role of halakha, Jewish religious law, in the lives of the Jews. A persistent, bitter, and at times even violent struggle erupted between followers of Jewish Enlightenment and the rabbis, a Kulturkampf, over the shaping of the culture, identity, education, and daily practices of the Jews. Since then, the struggle over the shape of Jewish culture has been a constant thread in the life of the Jewish people in the modern era. As could be imagined, a major site of the struggle has been the legal arena. Britain governed Palestine for 3 decades between 1918 and 1948, the year in which Israel gained independence. In the course of these 3 decades, the British conducted a massive and highly successful campaign for the Anglicization of the local law of Palestine and of the professional culture of the local community of lawyers. As a result, the Jewish lawyers in Palestine acquired their legal training in strong attachment to the law of England and developed profound identification with and loyalty to the legal culture of England, and in fact to the legal culture of all other common law countries. The love in which local Jewish lawyers fell in love, the extent to which they fell in love with English law is amazing. Even German jurists, Jewish German jurists, who got their legal training in Weimar in the 20s and then immigrated to Palestine in the 30s, and we all know how difficult it is to study law and then to move your legal knowledge from one legal system to the other. Even those German Jews who came to Palestine, German lawyers, fell in love with English law and became great admirers of it. Even them. These strong bonds with the common law is a major thread of Israeli law until this very day. The Supreme Court cites many hundreds of Anglo-American precedents every year. Anglo-American legal theories dominate Israeli jurisprudential discussion, and Israeli law professors routinely teach in countries such as the United States, Britain, Canada, and Australia. However, the process of the Anglicization of the law of Palestine has not gone without contestation. In those same years, the 3 decades between 1918 to 1948, a movement for the revival of Hebrew law was active in Palestine. Members of the movement strongly objected to the Anglicization process conducted by the British and argued that the new Jewish society in Palestine should adopt instead the provisions of the halakha, Jewish religious law, albeit following processes of secularization and modernization. A major source of influence over the movement for the revival of Hebrew law was the thought of the founder of the historical school of jurisprudence in German law, Friedrich Karl von Savigny. Just as every people, folk, has a unique language of its own that embodies its unique spirit, the Volksgeist, so every people has a unique law of its own that embodies its spirit, famously claimed Savigny, following the influence of Herder, of course. In Savigny's spirit, the movement for the revival of Hebrew law held that just as reviving the people's language, Hebrew, was part of the national renaissance of the Jewish people, the Jewish people should also return to its own law, the halakha, which embodies its unique spirit. May I say that any time I go to Berlin, I make a habit of visiting Savigny Platz in the western part of the city. Because for me, Savigny is a great hero because of his emphasis on the connection between law and the culture of a people. And except for that, it's a beautiful Platz. In the 1920s and 1930s, the movement for the revival of Hebrew law seemed to be quite successful. But eventually, the English option in the life of the Jewish legal community in Palestine, and later on in the life of the State of Israel, enjoyed an unequivocal victory over the halachic Hebrew law option. Why is it that the Anglicization process conducted by the British in Palestine was so crucially important for the future of the State of Israel? The answer lies in the fact that every letter of Anglo-American law embodies the values of liberal political theory. This means that since the inception of the state, the Supreme Court of Israel and all other jurists of the country, law professors, other judges, lawyers, all of them has served as the primary agents for the introduction of the principles of liberalism into the country's political culture and into the country's culture at large. As part of that, following the realization in the early 1950s that the Knesset, Israel's parliament, would not live up to the task of enacting a written constitution, the Supreme Court began to present itself as the creator of an unwritten constitution. That is to say, as the protector of a series of fundamental political and civil rights and liberties that presumably are at the disposal of the state's citizens unless explicitly overridden by Knesset legislation. Ruth Gavizon, professor of jurisprudence at the Hebrew University of Jerusalem, rightfully noted in 1990 that the achievements of Israel's Supreme Court in those years, and I cite, in the absence of a constitution, a written constitution, the achievements are at times even more impressive than those of the American Supreme Court in the presence of a constitution and a Bill of Rights. And this is an interesting point. Our constitutional law in that era was developed through administrative law. Constitutional law at that time was a very uninteresting and unimportant topic. Administrative law was the important topic, and our constitutional law was developed piggy riding, so to speak, on the back of administrative law. So it went on as follows. A citizen of the state would submit a petition to the Supreme Court claiming that his or her right was violated by a state bureaucracy. So it was the citizen against a state bureaucrat. And in writing the opinion, the Supreme Court would have told time and again the state bureaucracy the essences of liberal constitutional law, telling them these are your limits when you're dealing with the citizens of the states. So these are texts of constitutional law. But in the context of petitions submitted against state administrations. So as I said, it was administrative law that was important at the time, and constitutional law was secondary. However, all of that dramatically changed in the course of the 1980s and 1990s. What since the inception of the state looked for some 3 decades like a continuous, stable process of implanting liberal values in the country's political culture was shattered in the 1980s and 1990s. In the course of the 1980s and 1990s, the Supreme Court adopted and applied sweeping extreme judicial activism. And when I use the term judicial activism, I borrow it from American political science. According to American political science, a court is activist the more it intervenes in decisions undertaken by the other branches of the state. And the less it intervenes and the more it shows deference to those decisions, it is a restrained court. So that's the way I use the term judicial activism. Indeed, there's a consensus among comparative law scholars about this characterization, that we witnessed sweeping judicial activism. For example, Robert Kutter and Tom Ginsburg report the findings of a survey conducted among a group of comparative law scholars who ranked the Israeli court as the most daring in the world. Likewise, Amnon Rubinstein, one of Israel's most respected legal academics, writes that the years of Aaron Barak in the court, and I cite, gave the court a name as the most activist in the world. And Rubinstein adds the following far-reaching and striking words. And he writes, in many senses, the court under Barak's leadership has turned itself into an alternative government. The court is an alternative government. The court's activism was manifest in its rewriting of some of its traditional legal doctrines and in its devising some wholly new doctrines. The court very much expanded its standing doctrine, opening its gates to public petitioners. The court brought to the vanishing point its non-justiciability doctrine, making almost all decisions of the government and the state's administrations justiciable. The court developed the tests of reasonableness and proportionality as its new means for reviewing the conduct of the government and the state administrations. The court expanded its review power to many spheres that had hitherto been kept outside of its purview, including defense, foreign affairs, and socio-economic policies. We had wars with the Palestinians in 2002. We had wars with the Palestinians several times, unfortunately, in Gaza. In the course of these wars, while soldiers are fighting, petitions were submitted to the court. The court dealt with those submissions, with those petitions, all meant to constrain the activities of the Israeli Defense Forces in the course of the wars in the West Bank and in Gaza. This is amazing. Soldiers are fighting, and the court intervenes and imposes constraints on the IDF. It's unprecedented. The pinnacle of the court's activism was its 1995 Bank HaMizrahi case, in which, abandoning its former doctrine of parliamentary supremacy, the court held that it is authorized to annul Knesset legislation if it finds it to contradict the provisions of the Basic Law, Human Dignity and Liberty, and the Basic Law, Freedom of Occupation, both enacted in 1992, and perhaps also the provisions of all the other basic laws enacted by the Knesset since the late 1950s. All of those basic laws basically deal with the composition of the state institutions and have nothing to say about the liberal rights of the state's citizens. Now, the extensive changes that took place in the court's jurisprudence in the 1980s and 1990s immediately raised two puzzles, big puzzles, I would claim. The first, the changes took place even though until this very day there's a wall-to-wall consensus in the Israeli legal community as to the great historical legacy of the judges of the first generation, those who staffed the court until the late 1970s. It is held with no exception among Israeli jurists that the opinions of these justices, the justices of the first generation, met not only with the highest professional standards, but also that in spite of great difficulties, they were acting within the context of a collectivist ideology at the time, nation building, implanting liberal values. So that in spite of great difficulties, they succeeded in implanting liberalism's major values in the country's political culture and in the culture of the country at large. Put differently, The extensive changes that took place in the court's jurisprudence within a short span of time in the course of the 1980s and 1990s occurred even though there was not a single person at the time in the country's legal community who held that there was a problem in the legacy of the justices of the court's first generation, and certainly not wide-ranging problems that necessitated far-reaching corrections. The second puzzle is jurisprudential. Modernity does not see the past as having abiding force. In one of modernity's constitutive and most famous articles, an answer to the question, what is enlightenment, from 1784, Immanuel Kant says that the motto of the Enlightenment is, have courage to use your own understanding. What Kant meant to say is that the modern person is supposed to emancipate herself from religious and cultural traditions, and that her reliance on her reason should substitute the reliance of the pre-modern person on the imperatives of traditions. Yet there's one major exception to this attitude of modernity towards the past: Anglo-American law, the common law, of which Israeli law is part. In contrast to all other spheres of modernity, in the common law, the past is binding. A lawyer is not entitled to resolve a case in any matter deemed suitable by her. She needs not only to consult past precedents, but also to view them as having binding force on her. Anglo-American law is therefore a conservative, quasi-religious element in a modern era based on emancipation from the binding force of the past. Nonetheless, within a short span of time, in the 1980s and 1990s, the Supreme Court of Israel effected far-reaching changes in the content of the law left behind by the justices of the first generation. Now, how should these changes be understood? I wish to argue that the changes in the court's jurisprudence in the 1980s and 1990s need to be understood in the context of three great historical processes that began to unfold in Israel since the late 1970s. The first historical process was the decline of the cultural, political, and social hegemony of the labor movement that had led Israel for over 4 decades, since the mid-1930s to the late 1970s. A hegemonic situation prevails in a country when one social group, the hegemonic group, succeeds in controlling 3 foci of power: the central institutions of the state, the central institutions of civil society, and thirdly, and perhaps most importantly, the hegemonic group is also able to control the shaping of the key elements of the country's culture, such as the country's regime, political culture, economic order, and the people's historical narrative. For 4.5 decades, between the 1930s and the late 1970s, the labor movement stood at the center of the hegemony that led the pre-state Jewish society in Palestine and then the state of Israel. As part of that, the labor movement succeeded in imposing a hegemonic cultural package premised on the notion that Israel was to be a secular, democratic, modern state closely linked to Western culture and technology. But since the late 1970s, the labor movement lost much of its foci of power in the state and found its culture challenged. This brings me to the second great historical process that began in Israel in the late 1970s, the rise of a new self-perception among religious Zionism, according to which this group is the one that should form and lead a new hegemony to be formed in Israel in the closing decades of the 20th century and the opening decades of the 21st century. This new hegemony was supposed to be based on the halakha, Jewish religious law, and on the rich legacy of traditional Judaism. As a result of these two processes, that is to say the decline of the labor hegemony and the rise of a self-perception among religious Zionism that they should be the leaders of a new hegemony, the struggle over the shaping of Israeli culture, the war of cultures the cultural camp, that seemed to be dormant for several decades, the years of the hegemony, was renewed, and the two main approaches that surfaced were the same that had battled each other since the rise of Jewish enlightenment in Berlin in the last 2 decades of the 18th century. It is my claim that in this renewed war of cultures, an alliance was formed by the Supreme Court on the one hand and the liberal, secular, pro-Western group on the other. Needless to say, this was not the outcome of any explicit conspiracy. Its source was stronger than that. The cultural affinity between the court, as the #1 liberal state institution in the country, on the one hand, and the liberal, secular, pro-Western group in the society on the other. So this was a cultural bond, not any explicit conspiracy between the court and the liberal sector, the liberal court and the liberal sector in the civil society. As part of this inexplicit alliance, the court opened up its gates for the liberal, secular, pro-Western group to allow it to submit petitions aimed at disrupting the workings of governments led by coalitions composed of nationalist and religious parties. Justice Neil Gorsuch, who was appointed to the United States Supreme Court last April, wrote some 15 years ago that, and I cite, American liberals have become addicted to the courtroom, relying on judges and lawyers rather than elected leaders in the ballot box as the primary means of effecting their social agendas. That's Neil Gorsuch about American liberals, leftists. Had the word American been substituted by the word Israeli, this would have been a very accurate depiction of the Israeli case. Now, how is it that the court could do that, these far-reaching changes, with the support of the liberal sector? My answer is that the liberal sector found itself in huge anxiety following the demise of the secular, liberal, pro-Western hegemony. I spent several wonderful months reading Haaretz, the Israeli equivalent of the Frankfurter Allgemeine Zeitung, the New York Times, the Le Monde. Okay? It was wonderful to read them. I read all of Haaretz since 1977 to 1990. I read all the literature I could put my hands on of that period. And you could tell the anxiety of people whose hegemony, whose culture is being shattered, undermined, challenged. We cannot understand what happens to people who go through this earthquake in the course of their lives, in which they find their cultures, the culture in which they live, challenged. And the alliance between the liberal court and the liberal sector in the society was based on this profound cultural anxiety and cultural similarity between the court and the group. Habitus, to borrow from Pierre Bourdieu, and Raymond Breton, a great Canadian sociologist, says that people want to see in the political institution of the states people who resemble themselves, who have the same diction, who have the same names, who have the same biographies. And since 1977, these Ashkenazi, secular, liberals saw themselves immediately surrounded by people who don't look like themselves. They have different dictions, they have different biographies, they have different names. And you can imagine the extent of anxiety that comes with such far-reaching cultural changes. So that's the reason why this bond was created and why for many years nobody criticized it. And the court could go on smoothly with effecting those far-reaching changes in its jurisprudence. The changes that the Israeli Supreme Court effected in its jurisprudence in the course of the 1980s and 1990s have inevitably put it on a collision course with Israel's political system, which since 1977 turned more nationalist and more religions. And when I talked here 2 days ago about liberalism finding itself squeezed, so to speak, in between nationalism and religion, both working in the condition of a synergy. The stronger religion is, the stronger nationalism becomes. And the opposite, this is the situation of Israel. So Israeli liberalism, since 1977, functions in those conditions of being squeezed in between these two huge forces, nationalism and religion, which formed up an alliance since the late 1970s. Also, the court's sweeping activism and its positioning of itself as a political actor inevitably made it lose legitimacy among social groups that do not fully endorse its liberal values. And there are many manifestations for that. Beginning with polls taken time and again, so showing a clear and sharp decline in the amount of trust people in the country have in the Supreme Court, and pronouncements of politicians, of public figures against the court. So the court lost much legitimacy because of its identification with one of the two contending social groups in this cultural camp. Moreover, a few months after the enactment of the two basic laws of 1992, Basic Law Human Dignity and Liberty and Basic Law Freedom of Occupation, Aaron Barak, at the time a justice of the Supreme Court, who 3 years later became the court's president, published a law review article in which he claimed that the enactment of these two basic laws amounted to a constitutional revolution. The two basic laws are Israel's constitution, claimed Barak, and through their enactment, Israel joined the ranks of all enlightened countries having a written constitution. Barak repeated this argument in other law review articles and in his opinion in the great Banca Mizrahi case of 1995. I don't have time to talk about that, but I strongly object to judges writing law review articles. Barak continues to write that all the time in the 20 years of being a member of the court. The reason is that the common law is based on Aristotelian practical wisdom decision-making processes. Aristotelian practical wisdom decision processes are based on watching the facts of a real-life case and coming to a normative conclusion, as opposed to coming to a normative conclusion in abstract ways, okay? It's Aristotle versus Plato, if you want. So if you are a member of a common law court, you're supposed to work in the Aristotelian practical wisdom way and not write abstract law review articles. You have a case, you see the facts, and then you devise the normative solution. So that's why I object to it. Getting back to the panel yesterday with the judges, which was highly interesting for me, as all the panels, by the way. Barak's constitutional revolution argument is problematic on two counts. First, the argument is legally flawed. Barak draws mainly on the American experience of constitution making, but there's a world apart between the American case and the Israeli case. Nobody at the Knesset, Israel's parliament, thought of at the time that by enacting the two basic laws, the Knesset gave the people a constitution. Indeed, until Barak's claim that the two basic laws amounted to a constitution, there was not a single person in the country, except for Barak himself, who thought that in enacting the two basic laws, Israel adopted a constitution. The two basic laws were enacted through the procedure for enactment of regular Knesset legislation. And they were enacted with the participation of less than half of the members of the Knesset. If the Knesset wants to amend them, they can amend them in the majority of 1-0. Okay? And they were adopted by less than 60 members out of the 120 members of the Knesset. The two basic laws are very thin statutes in terms of their content. That is to say, most central liberal rights, such as freedom of speech and the right to equality, are not mentioned in them. And their enactment was barely mentioned in the press the next morning. Could you believe a constitution not mentioned in the press the next morning? This is Barak's Israeli constitution. Okay. The second problem with Barak's constitutional revolution argument is that it consolidated the religious and national groups against the court. Because of the court's extreme activism, these two groups have been mounting criticism of the court for several decades now. But the constitutional revolution argument was one bridge too far, to borrow from a famous World War II book on a famous battle waged by the Allies in the Netherlands. The religious and national groups claimed that if there was a constitution-making process in the country, how was it that they had not invited to take part in it? Moreover, and this is the main point, because the two basic laws of 1992 are very thin statutes in terms of their content, the Supreme Court took it upon itself to fill them up with the rich content of liberalism's matrix of negative rights. For the religious and nationalist opponents of the court and of Israel's liberalism, this meant not only that the court, taking everybody by surprise, pronounced the existence of a constitution, but also that it was the court that writes the constitution and determines its content. So first you tell us that there's a constitution, and then you write its contents, filling the two very thin statutes with content. And may I cite Moshe Landau, a great justice of the first era, until the 1970s, who was the Chief Justice of the Court in the 1970s. By the way, was born in Danzig. I think it's the third or fourth German influence over Israeli law and culture that I mentioned in the past 20-something minutes. So Landau was a great judge, a great liberal judge, said that the Israeli constitution claimed to have been enacted by Barak is the only constitution in the world created by the mouth of a court. That was Moshe Landau, the great Moshe Landau, may I say. Everybody agrees with regard to his greatness. So needless to say, Barak's constitutional revolution argument added much fuel to the religious and nationalist opponents of the court and of Israel's liberalism in the war of cultures, the culture camp that re-erupted in the country in the late 1970s. And needless to say, all of that further weakened the court and weakened its ability to protect the liberal rights of the state's citizen. I want to get back to some of the 2 more minutes. Okay, Matthias? Some of the things we've been discussing here in the past 3 days. Werner Gerpart talked about constitutional symbolism of national unity. That's not the case with regard to the Israeli constitution. You talked about normativity at its peak, that a constitution is protected from change. As I just said, the Israeli constitution, if there is one and there isn't one, can be changed by the majority of 1-0 by the Knesset. Okay? What a bizarre understanding of the concept of constitution. Now we talked about constitutional ritualism, celebrations, festivities, holidays. None of that. And if there will be festivities, the opponents of the court will come to the streets to protest against those festivities. You talked about constitutional narrative. Well, I'm sad and even ashamed to say that the right wing in Israel, that the religious sectors talk in terms of a judicial coup d'etat effected by the court. And for me, this is the worst thing about the whole constitutional revolution argument made by Barak. Because we all know the importance of culture, right? You know that Bill Shankly, the great legendary manager of Liverpool, once said, football is not a matter of life and death. It's much more serious than that. So we are dealing with something very serious, culture. As human beings, we are constituted by 2 great systems, our biological genetic system and our cultural system. Culture is so important, as Matthias taught us yesterday, and many others. We all know that. And for Barak to make this unilateral measure, which brings about a reaction in terms of this is a judicial coup d'etat, undermines the very essences, for me, of the political culture. And culture, for me, as for Matthias and for many others of us, is much more important than the written words of this or that legal documents, including constitution. So in terms of the culture, this is what bothers me, that people talk about usurpation, about coup d'etat committed by the court. And Werner, you talked about materiality, right? No materiality. And if there will be statues or paintings, they will be desecrated by the opponents of the court, who feel insulted and alienated. Okay. So I'll conclude by saying that the Talmud says that what wisdom has made a crown for its head, modesty has made the heel of its soul. Listen to this. This is truly wonderful. The Talmud tells us, okay, wisdom is the highest intellectual virtue. Now we are telling you that what wisdom makes a crown of its head, modesty, a non-intellectual, one of the non-intellectual, not the supreme non-intellectual virtue, modesty has made the heel of its soul. The Talmud means to tell us that modesty is a virtue far superior to wisdom. It is a truism that in recent decades, the Supreme Court of Israel has not made itself a name in the domains of modesty. The question is whether it fared any better in the domains of wisdom. Thank you very much.